Introduction to immigration law in the United Kingdom. Immigration law in the United Kingdom regulates the entry, stay, rights, and removal of non-citizens. It determines who may lawfully enter the country, under what conditions they may remain, and the circumstances under which they may be removed or deported. This area of law sits at the intersection of public law, administrative law, human rights law, and international law. It involves a complex system of legislation, immigration rules, government policies, and judicial interpretation. The central authority responsible for administering immigration law is the UK Home Office, which makes immigration decisions through its departments responsible for visas, asylum, and border enforcement. For anyone, understanding immigration law requires familiarity with the statutory framework, the immigration rules, the immigration control system, human rights, human rights protections, appeals, and judicial review procedures. The concept of immigration control. Immigration control refers to the legal framework governing who may enter or remain in the UK. Under UK law, individuals fall into two broad categories. One, British citizens who have an unrestricted right to enter and live in the UK. Two, non-citizens, foreign nationals whose entry and stay are controlled by immigration law. Immigration control primarily applies to foreign nationals who require permission to enter or remain in the country. Permission is typically granted through entry clearance, a visa issued before arrival, leave to enter, leave to remain. These permissions are regulated under legislation such as the Immigration Act 1971. Historical development of immigration law. Understanding immigration law requires examining its historical evolution. Pre-1971 immigration control. Before modern immigration legislation, the UK had relatively open migration policies, particularly within the British Empire and Commonwealth. However, increasing migration led to legislation through controls, introducing controls such as Commonwealth immigration restrictions, border control mechanisms, and the Immigration Act 1971. The modern immigration system began with the Immigration Act 1971, which established the basic framework still used today. The Act introduced the concept of leave to enter and remain, immigration officers at ports of entry, deportation and removal powers. This Act remains the foundation of UK immigration law. Major sources of UK immigration law. UK immigration law derives from multiple legal sources. One, primary legislation. These are civil acts of parliament govern immigration matters, including Immigration Act 1971, British Nationality Act 1981, Nationality Immigration Asylum Act 2002, UK Borders Act 2007, Immigration Act 2014, and Immigration Act 2016. These statutes establish the legal authority for immigration control. Two, the immigration rules. One of the most distinctive features of UK immigration law is the UK immigration rules. These rules are made under statutory authority and set out detailed criteria for immigration decisions. They regulate areas such as visa eligibility, entry requirements, duration of stay, settlement eligibility, work permissions. The immigration rules function almost like a comprehensive code governing immigration policy. Three, case law. Immigration law is also shaped by judicial interpretation, Important courts include the UK Supreme Court, Court of Appeal of England and Wales, Upper Tribunal, Immigration and Asylum Chamber, First Tier Tribunal, Immigration and Asylum Chamber. Courts review government decisions and ensure compliance with legal standards. 5. Categories of immigration status. Individuals entering the UK may obtain different types of immigration status. 1. Visitors. Visitor visas allow individuals to enter for tourism, short-term businesses, visiting family. Limited study visitors generally cannot work or settle permanently. 2. Work immigration. The UK has several work visa routes, including the skilled worker visa, the global talent visa, temporary worker visa. Most work visas require employer sponsorship. Student immigration. International students enter the UK through student visa. Requirements typically include acceptance by an approved educational institution, evidence of financial support, English language proficiency. Students may also have limited work rights, such as 20 hours per week. For family immigration, family members may join UK residents through family immigration routes. These include spouse or partner visas, parent visas, child visas. Family immigration also involves strict financial and relationship requirements. Settlement and permanent residence. Long-term migrants may eventually obtain permanent residence. In the UK, this status is known as indefinite leave to remain, ILR. ILR allows a person to live in the UK permanently, work without restriction, access certain public services. Many migrants qualify after 5 or 10 years of lawful residence. British citizenship. After obtaining settlement, individuals may apply for citizenship under the British Nationality Act 1981. Citizenship may arise through birth in certain circumstances, descent, registration, and naturalization. Naturalization generally requires good character, residence requirement, and passing the life in the UK test. Asylum and refugee protection migration law also addresses humanitarian protection. Individuals fleeing persecution may apply for asylum under international law, particularly the 1951 Refugee Convention. Applicants must show a well-founded fear of persecution based on factors such as race, religion, nationality, political opinion, membership of a particular social group. Successful applicants receive refugee status or humanitarian protection. Immigration enforcement. The government enforces immigration law through several mechanisms. Key enforcement activities include border inspections, immigration detention, removal and deportation, workplace enforcement. These powers are exercised by agencies such as the UK Border Force. Appeals and judicial review. Immigration decisions may be challenged through legal procedures. Immigration appeals. Appeals are typically held by the First Tier Tribunal, Immigration and Asylum Chamber. Further appeals may proceed to the Upper Tribunal, Immigration and Asylum Chamber. Judicial review. Where no appeal exists, individuals may challenge unlawful decisions through a process called judicial review. Judicial review ensures that migration authorities act lawfully, rationally, and fairly. Human rights and immigration law. Immigration law must comply with human rights obligations. Under the Human Rights Act 1998, courts must interpret immigration decisions consistently with the European Convention on Human Rights. A key provision of Article 8, which protects the right to private and family life. Article 8 is often invoked in deportation cases, family reunification cases, and long residence cases. Key themes in UK immigration law. Several themes dominate modern immigration law. One, border control. This ensures that entry into the UK is regulated. Two, economic migration. This allows skilled workers and students to contribute to the economy. Humanitarian protection, providing refuge to those fleeing persecution. Family unity, allowing families to live together. Balancing these competing objectives remains a central challenge for policymakers. In conclusion, immigration law in the United Kingdom is a complex and evolving legal framework regulating the movement of people across national borders. It is built upon statutory legislation, the immigration rules, judicial interpretations, and international human rights obligations. Mastering immigration law requires understanding the structure of the legal framework, the decision-making process of immigration authorities, and the legal remedies available to migrants. As global migration continues to shape modern societies, immigration law remains one of the most dynamic and politically significant of areas of contemporary legal practice. And this is where I draw the curtain.